Okay, welcome back, everybody, and thank you for joining us here today for this panel, this conversation. We will talk about the aftermath of IPR, which primarily is reexamination, and this is an issue that came up a little bit yesterday, and it will, well, I think it'll be an interesting conversation because it's one where I think we have a variety of different thoughts on the matter, and we probably understand what it is that the statute says, and maybe there might be some thoughts about what it is that we would prefer the statute said, and then also maybe some, well, just some certainty. And that seems to be a theme of what we've been talking about over the last couple days. So without any further ado, let me introduce the panelists, and we'll go from the audience's left to right. We have Scott Weidenfeller, and Scott is a partner at Covington in Berlin. He rejoined the firm after serving as vice chief judge at the PTAB, and in this role he had significant responsibilities for developing and implementing and communicating board policy. So thanks, Scott, for joining us here today.
Thanks for having me.
Next to Scott is Clint Wilkins, and Clint is a partner at Haynes and Boone, and he focuses primarily on patent law and leverages his technical knowledge and experience to assist clients, particularly with inter-parties review and patent preparation and prosecution, as well as patent litigation support and related counseling. Thanks, Clint, for joining us. And Clint is author of one of the articles that make up the CLE materials that are on the panel page. Next to Clint, we have James Loveson, and Jim is a partner at MBHB, and he chairs their PTAB Trials Practice Group, and he works litigating patents, trademarks, trade secrets, all matters of IP. So thanks for joining us here, Jim.
Good to be here.
And last but not least, is Scott McEwen, who's the co-chair of the program and also a shareholder for Wolf Greenfield. And his practice focuses, as you probably know, primarily on post-grant review matters and IPR matters, and he also is the author of patentspostgrant.com. So, Scott, let's start with you, if we can here, and get your preliminary thoughts on this topic. I know this is a topic that's near and dear to your heart too. You do some work in this area, the reexamination after the fact, and I think you do it on both sides of the V, as it is. So, what are your thoughts on this preliminary?
You know, reexamination, I think, for a while after the AIA was somewhat of a forgotten practice, and recently it's been reinvigorated. I think first by the discretionary denials that, as we discussed yesterday, if you went to the PTAB, filed your IPR, and the PTAB basically comes back and tells you that, well, we're not going to look at the merits because of these policy reasons, and therefore we're done. I think as a patent challenger, the mindset is, well, I've got a 103 case here. It's probably not going to win the day in the district court, even if ex parte is not as robust because I can't participate. You're right, I may as well file it. And so I think that started to drive the numbers up somewhat in terms of people finding a use for re-exam in sort of a PTAB dominated world, and some developments have happened since then. I think some of the member organizations have started using re-examination as a tool. I think there's also been an uptick on double patenting after in-ray select. So the numbers last year were, I think there was maybe a 15-20% uptick on filings. And so, from a objective viewpoint, I think stakeholders are finding more use for reexamination in those contexts. I think the one that we tend to talk about more so than all of that is those PTAB petitioners that go to the board and actually get a merits-based determination that you missed, your grounds aren't good enough, go away, and there's no estoppel that sticks to that determination at that point. So then maybe a year, in some of the cases I've been involved in, a year or two later, when you're on the verge of trial, suddenly a reexamination pops up from that failed petitioner, and then that reexamination goes forward, and there may be some attempt to avoid the trial. And I think that is sort of the circumstance that's been seized on by some of the legislators in the Prevail Act and in other spots that, maybe that's not the way we want the system to work.
Okay, great. Thanks. Jim, let's go to you next. Where do you want to start the conversation with your preliminary thoughts?
Well, if we set aside legislative reform, I think the current system has a framework to deal with issues in this IPR aftermath, and 325D is the primary vehicle like the office can use to say, hey, you had this failed IPR is what people call them, and if it's a carbon copy, the CRU can turn the petition away. So I think there are tools for the office to use to prevent unfairness. From petitioner side, if there's a world where you don't get a full determination, a denial of institution is not appealable. Maybe there's expert testimony. I know, Jim, you mentioned that today. Poper testimony. So there's a world where a failed IPR might merit a real look by the office on the full merits.
Okay, great. Thanks. Clint, let's turn to you next to get your preliminary thoughts on this.
Yeah, I think when you have IPRs that get denied based on discretionary grounds, ex parte re-exam can be a way to view the patent system being, weeding out bad patents. I mean, a party not getting an opportunity in the IPR due to some discretionary denial, and I think Scott touched on this, the initial reinvigoration of ex parte re-exam was due to a lot of fintive denials. People wondered, well, if I'm not going to get my shot based on the trial schedule, then I'll look at ex parte re-exam. I think it's not a given that it's automatic, that if a party loses at institution, even if it's on the merits, that they're going to then retool. I think people also need to keep in mind the differences between ex parte re-exam and IPR, and sort of look at re-exam with a critical eye. And I've had clients come out both ways on that, where one client, it may be just part of their playbook. If they lose at institution, then they're going to immediately look at re-exam. And I've had another client look critically at, the differences between IPR and re-exam. And for example, the fact in re-exam that you can submit all the prior art from the litigation in IDS if you're a patent owner, that creates sort of practical estoppel, or it can in the district court. Some people call it practical estoppel. So it's not a given that re-exam is something that's automatic if you lose at the IPR institution stage.
Okay, and we're going to come back and talk about that a bit more in depth here in a minute. But Scott, let's get your preliminary thoughts here on the topic.
Sure. So I think, as several people have said, that it sort of became more of an issue with discretionary denials, but it's actually a more interesting thing when it's not discretionary denials, but a denial on the merits, and you're coming back. There's the 325D issue, and you have, you've got board precedent that says things about 325D. You've got board decisions that say things, and you're going in front of an examiner who doesn't read board decisions other than when he or she's being reversed, usually. And so it's a different decision maker, a different person, not legally trained the way the panel of judges are. And so it's an interesting sort of mix of things that the examiner has to think about. And obviously the CRU coordinates with the PTAB, but they don't go back and forth in every particular case and so you can end up with very interesting and disparate results as a result of the decision makers.
So this may not be a fair question, but since you're the former patent office representative on the stage, can you give us an idea, what is the difference really between the standard, in your mind at least? And maybe I'll ask all of you that, so it's not, we don't just single out Scott for that, but what's the difference between reasonable likelihood that and substantial new question of patentability from your perspective?
So I think they're actually different in in two ways. One is, the substantial new question. I think substantial is a lesser threshold than reasonable likelihood of success. I think you say, okay, well, there's something interesting here. You may end up prevailing as the patent owner at the end of the day, but there's something interesting here. But it also has to be a new question. And the way that's been treated is a little different, I think, than the 325D determination, where it's, the board has a lot of discretion, and the CRU has the same discretion under 325D. I'm not sure that they fully pair up in the way they apply 325D, but the new question aspect is something that I think is a little different from reasonable likelihood, where reasonable likelihood can actually not necessarily be a shockingly new question as long as it passes through 325D, where it's not the same or substantially the same art. I think it can be a non-new question if it's cumulative art, for example, and I think that's. I do think so. So it's higher in the new sense, but it's lower in that substantial is different from reasonable likelihood.
So I wonder if we're all going to give the same answer or not. So Scott, let me try go with you. What do you see as the difference between these standards?
Yeah, well, the standards are different, and you just have to look at the grant rate of reexaminations to appreciate it, right? You get 96% substantial new question, and I think from a layperson's viewpoint, substantial sounds, well, substantial, right? What's the difference between, these words, reasonable likelihood, substantial? But the actual legal standard is, so I can submit a piece of prior art in a reexamination, and would this piece of prior art be important to a reasonable examiner? So would it at least be something that showed up on an 892, right, some examiner search form, that the examiner would have at least felt like it was good enough to list? Doesn't mean it's good enough to reject the claims, doesn't mean they would have used it in a rejection, where reasonable likelihood is a couple steps above that, which is, well, forget about whether the art's important. Does it rise to the level where you could actually use it to invalidate claims? So, there was a lot of argument when we didn't have the AIA that SNQ was just too low. The last year of inter-parties re-exam, we actually started using reasonable likelihood. So, the reasonable likelihood relates to ultimate outcome. Are you reasonably likely to prevail? Substantial new question is, are we in the ballpark? And that used to be the standard for inequitable conduct as well. So Theracense went to but-for. We used to have substantial new question, which was, is it in the ballpark? So we had a lot of inequitable conduct accusations. So it's a very liberal standard, and reasonable likelihood is more key towards ultimate success.
Okay. Jim, what's your answer to this? Get you on the record for your answer.
Yeah, no, I agree with both comments. I think new drives the SNQ and not substantiality. But I think another way to look at it is, Scott pointed out the stats about ordering re-exam, but that doesn't necessarily mean you're going to get a first action. And then there's a lot of claim amendments in re-exam where there's not an IPR, right? Motion to amend practice is harder to carry. And so I think SNQ in the context of amending claims in re-exam and being in front of the CRU matters when we're comparing the two standards.
Okay, great. And last but not least, Clint, do you agree with these guys? Is it different in your mind?
Yeah, I agree that, so there, like they mentioned, there's two parts, substantial question and then is it new? And I think substantial question, most people agree, is a lower threshold than reasonable likelihood to prevail. And then the new aspect of substantial new question, that I don't think it's entirely been worked out how that compares to 325D. And just to take a step back, make sure everybody's on the same page, In re Vivint was the case a few years ago where the Fed Circuit said 325D discretion applies also to ex parte re-exams. Mm-hmm. So I think it's still sort of getting fleshed out. What is the difference between new and, what do you have to show there versus 325D type showing?
So, okay, so you're all on agreement. The one thing, basically, I think you're all in agreement. The one thing that bothers me, just fundamentally bothers me, is that there can be a reexamination of any kind after a failed IPR. Because in my mind, and let me take a step back, because I also think that, so if I were director, I think like, what would I do if I were director? If I were director, I would actually probably want to have fewer IPRs, and I'd want the board to spend more time doing each of those IPRs. And I would probably do some other things that we talked about yesterday, have not the merits panel be the decision-making panel, those types of things. And I think there's plenty of work for the board to do, and I would rather them do like a real, like A+ job across the board with all the stuff that they do. And so I'm always thinking about allocation of resources, because their resources are finite. So I don't understand, and I want to ask you all to explain this to me, and I get it, but from a philosophical level, I don't get it. I get it from the legal level, but why, when you have the PTAB that is going to be the ones that are going to get the appeal, they're going to decide the IPR, and they're the ones that are going to get the appeal from the reexamination, why, if they have passed, should it go through another avenue to get back to them under a different standard? And this bothers me about litigation across the board. We've already started seeing where depending upon where the challenge originates on the claims, when it gets up to the federal circuit, the claims are either valid or they're invalid. And I don't know how you can have valid and invalid the same claims on, but all of this just bothers me. So set me straight. Who wants to take the lead here? Clint, you wrote the article. Do you want to go first?
Sure. I have a hard time, with the sort of philosophical question, and I don't know that I can address that of, should you be able to do it? All I can say is the statutes allow it, and it really arises from, in my view, 314 has the language may, and that opened the door, or it says they may not institute unless these requirements are met, and that has opened the door to discretionary denials, whereas the statute 35 USC 303 says it uses the word will, which is like shall. The director, I forget if it's the director, but the S&Q shall be found within 3 months, and so it's really not. It's just a different ways the standards, the statutes have been written that allows this to happen. And I know you've touched on this and others. The Prevail Act tries to cut off, tries to address this by setting a time bar, for example, on reexams. And so that would effectively cut out this filing reexams after failed IPRs at institution.
Yeah. So Jim, what are your thoughts on this all around? I mean, is it good? Is it bad? And one of the things Clint mentioned when he first talked, and we should probably kick around as well, or at least put on the table for anyone who wants to comment on it, is should people be doing this strategically? Is it the right choice strategically, even if you can do it?
So,
and you feel free to give the lawyer's answer, it depends, and then just explain on what.
Sure. I mean, that's a given. It depends. I agree with Clint. The current system has allowed this path to go for petitioners when they haven't had a full merits proceeding, right? They don't get to cross the expert, right, if the patent owner showed up with an expert. They didn't get to have a oral hearing, because that goes away, right? The statute says you don't get a re-exam on the same claim for substantially same art. You could have raised if you lose the IPR. If it short circuits for some reason, the current system is you can go into the CRU, and I think the current system is we're not having a copy and paste of the failed petition. There's got to be something new to it, whether it's new art, whether it's a 103 instead of a 102. Whether it's a different emphasis on the art. So if we're at a policy level and we say pick your lane, right, there's a lot to say for that. But the current system, I think 325D, and understood the case law is developing, I think prevents a parade of horribles.
Okay. Scott, do you agree with that? Particularly the last statement on the parade of horribles.
I would agree with. I think Clint gave the legal answer as to why it's done differently. I think the big picture is whether, as an outsider, as a legislator, as someone on the Hill looking at this system, does it make sense that on the one hand, that the Patent Office can make a policy determination in the case of Fintiv, which I'm not a big fan of, but they made that determination, then you can go ask someone else and you'll get a different answer. And, the Patent Office could stop that, right? If you read Vivint, it states that, although 314A is particular to AIA trials, it's not to say that those factors never matter in re-exam. But as you know, Gene, the director would not only have to step in and say that we're going to start treating some of these re-examinations differently. Now you run into the politics of we're taking work away from the Patent Examiners Union by, cutting off some of these re-exams. And, unfortunately, the practical implementation of some of what probably should work, absent some kind of legislative mandate, is not really feasible.
Yeah, and I think what you just put your finger on it. What it bothers me is that you went into the agency and you asked for some review or relief, and you were stopped there. So you just essentially asked for the same review or relief elsewhere. And for a period of time when I was getting my LLM, I became the I forget what the title was. It was some foreign officer. We had to sign off on the visas and stuff for people. And in a lot of foreign countries, what I came to learn is if you say no, I would say, no, I can't do that. I can't just sign. You have to, one of the things was they had to demonstrate they had enough financial wherewithal to stay in the country. It's like, I can't take your word for that. I'm supposed to see something that says that, a letter of assurance, a bank account, whatever, anything. And in some countries, it's, well, I asked you, you said no, so then you're not the right person to make the decision. So I just keep asking, and they would go around and ask person to person to person. And in the U.S., it's the answer is no. The answer is no. It's not like, and if there was a different answer or appeal, I would let them know. But in a lot of countries, it's, well, somebody here has got the authority to break the rules. I just have to find out who that is. So it's always bugged me when you go one direction and the answer is no, and then you just see somebody back up and then they go for the same thing in a different direction, thinking they're going to get a different result. And I think fundamentally that's the problem that I have. But other Scott Weidenfeld, let's bring you into this here as well. What are your thoughts on what any of the gentlemen have said so far?
So I agree with what all three others have said, but I think the thing that's the trickiest is that the different statutory standards make it so that in a discretionary denial situation, make it so that the examiner can't say no for the same reason that the board did, other than 325D, but all the 314A, serial petitioning under general plastic, Fintiv denials, things like that, those tools are not in the toolbox the way I read the statutes for the CRU examiners to be able to say, I'm denying because there's a co-pending litigation. That's something that the agency says the authority for that is in the May under 314A, and that word is different in the re-exam statute. And so I think that's the sort of tricky thing. It gets a little more complicated when you're talking about a merits determination where the board says there's no reasonable likelihood of success on this, and here's why. And then someone comes to the examiner and says, well, I'm going to make this tweak to that. So it's a little different from so you can't deny under 325D, but I'm really responding to what the board said was missing in the analysis. And that's something that the board has the tools to say, no, that's serial petitioning. You're not allowed to take our answer and come back with it. But the examiner doesn't have that tool. And so I think that's sort of where it's most complicated for from the office's standpoint on trying to do what seems like it makes sense. You shouldn't have multiple bites at the apple, the agency has said, but as long as you meet the standard for substantial new question, which is a pretty low standard as we've been talking about, the agency sort of has to take it up, or
And
at least views it that way.
It's somewhat ironic that the reason we have may in the statute was because in reexamination, people were filing 9 serial reexam. I defended one case. We had 9 reexams over the span of 3 or 4 years. They lost one. They just filed another one. So when it came to the AIA statutes, well, we're going to fix that. Well, it's fixed, but yet it still isn't, right? You can still get back to that system, at least from the patent owner perspective.
So, and I know, oh, go ahead, Jim.
No, so I think the current landscape is, and I know maybe this isn't popular from a policy point of view, one IPR, one reexam, right? Those are 2, and I understand that, and we could call that serial or parallel, but I don't know that we're in a world where we have 9 reexams today. I think on one patent, on the same claims, right? I think the CRU has 325D, and I think they're armed with that, and they're thinking about those issues.
Well, most people are going IPR now, so that, you don't see the same interest in serial reexaminations as you did. But yeah, the 325D, I just view that as a very, very narrow exception. Vivint was, very unique fact pattern, and another issue with 325D is you've got examiners that are enforcing this, and very smart people, almost never attorneys, and we're asking them to interpret some of the case law and what is new, what isn't, and they don't tend to see some of the nuances I think that attorneys tend to see. So that's another, I think, shortcoming of any kind of gating mechanism you have in reexamination is it's in the hands of sort of the examining corps. I'm not sure that it's given the attention that it gets when the board does it.
Mm-hmm. Yeah. So, Clint, I saw you shaking your head, and you kind of brought this up a little bit earlier as well. Do you have some comments or thoughts?
Yes, a few different thoughts. Just echoing what Scott said, I'm not sure there are a lot of nuanced issues that are coming into re-exams now, and I'm just not sure the examining corps is the best position to handle those. The other one that we're probably going to touch on is collateral estoppel, and how you could possibly raise that in an ex parte re-exam, or whether that would be an argument that would prevail in a re-exam. That's another sort of nuance that would be challenging for the examining corps. Some of the things that I've seen also is the body of PTAB case law that's developed around 325D is not getting applied in the same way in the re-exam context, and so that's sort of a gap right now. Well,
let's just jump right on that, because that was actually exactly where I was going to go next. And is the question I have written from my notes when we talked about this was, is there a difference between the estoppel or issue preclusion between re-examination and post-grant proceedings?
So, coming out of a re-exam, right, I think the courts have said that's inquisitorial, right? That's not adversarial. So common law preclusion is different for that reason. Now, coming from district court to IPR, the adversarial, right? The Supreme Court had that B&B hardware case a few years ago. That's through trademark oppositions to district court. And so the Federal Circuit has applied that in a straightforward way from IPR to district court and IPR to IPR. Mm-hmm. But not so much re-exam to re-exam or re-exam to IPR.
So I guess that it bothers me in some ways. I mean, I guess what I'm looking for is, like, if the office has already considered this, whether it be an IPR or whether it be in re-examination, shouldn't that have some meaning? I mean, we're already in this conversation just kind of fundamentally discounting the fact that that what the examiner originally did gets any kind of deference at all. But it just seems like there's no deference. No matter you go into this door, there's no deference. You go into this door, there's no deference. You go into that door, there's no deference. And if we want to have a registration system, I think that's fine, or it's potentially fine if we work out the details. But we don't, and this costs a lot of time, money, and energy to get these rights, and it seems like nobody within the patent office gives anybody else's decision-making process any kind of second thought.
Well, part of that is the case law, right? In Ray Swanson was the case on, well, what is really different, and it's, well, the standards, is it a new light? And the new light could be, well, yeah, we looked at this reference, but, all the focus was on page 5. Now we're talking about page 8. That's the case law. So, from that perspective, if the question is on, well, issue preclusion, collateral estoppel, can we revisit the same issue? Based on the case law, it's not the same issue because the standard is pretty low on proving that it isn't. And it always gets back to your favorite case law, Gene, the blonder tongue of, well,
Yeah.
someone else is just challenging it and they're not the same as the last person. They're entitled to do that. And as long as it's literally not the same prior art and the same pages and the same figures and the same issues that previous examiner decided, then, it's a substantial new question.
Yeah, in blonder tongue, I think it's just it's terrible. I mean, in today's day and age, I mean, at some point in time, these rights they're not really rights. I mean, I think the Supreme Court, it was a faux pas because they were honest, right? When they said in the case where they said it's a franchise. That's a patent is a government franchise. It's not a property right, and that caught everybody by surprise. But we probably could have predicted that, regardless of whether they call it a property right or not, it's just not, and that bothers me, and I don't want to prevent people from having their day in court and challenging things and so forth. But then let's just say it's not a property right. And I guess what bugs me is the patents are limited compared to all other forms of intellectual property in terms of how long you can get to hold on to them, based on the belief that they're extremely strong. Now, we don't have extremely strong patents, so why aren't patents 40 years or 50 years or 100 years like copyrights? I mean, because, and I know, and we're not at the point where patents are as weak as a copyright, but I just get frustrated. Anybody have any thoughts on that, or Scott, you want to?
Sure. Yeah. So I think at the end of the day, a patent is a right to sue someone. That's all. It's not a say, you are doing something that I don't like, I get to sue you for it. It's not really a right to do anything yourself, and you're not required to do anything yourself either. And so that's sort of where it gets, because it's a right to sue people, we give due process rights to those who might be sued, and so that sort of is why our system is built such that you don't have these limits to challenges. And I think what's even trickier with ex parte re-exams is that you don't even have to identify who you are. You have to identify who you are, but you don't have to identify the real party in interest the way you do with IPRs. And so a law firm can file something and say, I'm filing, and I'm not identifying my client. And it's attorney-client privilege, the identity of my client. And so you can't really cut that off without changing the statute and saying you have to identify the real party in interest.
Right. Now, I get just upset by so much of all this stuff, because I get everything that you just said, but lost somewhere, and I don't know where it got lost. But the whole point of the patent system is to encourage people, rather than keeping it secret, is to come forward and make it public. And I just think increasingly we are living in a world where inventors have a lot more interest, and it's a lot more viable to just keep things secret and keep it, as a trade secret as long as you can. It's much cheaper, and then I don't think society benefits from that. But I just see I see the way that all these things have developed, and it just strikes me that this little piece here makes sense, this little silo here makes sense, and then when you try and put these silos together and try and make it fit together like a system, that's where I think it all falls apart. Does anybody have any thoughts on that before we switch? Jim, go ahead.
Yeah, I think the Prevail Act has two different points of view that, either one I think would probably wrap this door number one, door number two problem up, right? Estoppel is when the petition's filed, which is the opposite of, the statute now is you need a final written decision before we could bar IPR to re-exam. And then the other is this 1 year time frame Clint mentioned, right? So the re-exam and the IPR would be on the same 1 year clock when you're served. And that would also cause you to pick your lane.
Mm-hmm. So let me just ask this and get this out there. Scott, maybe this is for you primarily, but if any of the rest of you want to comment on it, what do you think the chances of Prevail passing are? Prevailing. Let's not say like this Congress, because it's not going to happen.
Yeah, it's
right?
not happening this year. It's probably not happening the following year. I'm not very optimistic, and that's not just an unsubstantiated opinion. As Judge Michel pointed out yesterday, we've seen this before, 7 times before, in the Stronger Patents Act and the Strong Patents Act. And so, I don't give that legislation any real chance. I mean, I know there was some attempt to, I won't say, well, maybe cheerlead a little bit yesterday, but I think there are some senators, notable senators involved that are on the committees and can call hearings to give the illusion of traction, but I don't think that particular piece of legislation is reasonable because it really is trying to do way too much. It's not to say that there aren't some good ideas in there. So I could see para at some point, 2 years from now, getting through, and maybe there's a PTAB provision or two that's thrown in, such as, providing a code of ethics or, some of these things that everybody can sort of agree on. But in terms of, wholesale changing, the structure of the PTAB, there's just too much value to too many stakeholders, I think, for that to get traction.
So what bugs me about it is I would agree that unlikely. There are some good ideas. There's ideas that could get passed. There's ideas that could get in there. But if you start like cutting this up and saying, okay, well, we can accomplish A, B, and C, but we can't accomplish D through Z. So let's do A, B, and C. Well, then you're going to have all the people that want D through Z out there saying, well, no, I can't support it because it doesn't give me what I want, and I don't care whether this makes it better. It's just, we want all of it or nothing.
And that's been the problem with the 101 legislation is, maybe this bill isn't perfect and it fixes 90% of the problem, but no one's going to agree until everybody gets everything they want, which is all legislation has sort of devolved into that these days.
So go ahead,
Judge
Jim.
Michel was encouraging people to take the win, and get involved and participate, right? Because if it's got to be perfect, it's never going to pass, right? And so AIA took years, and different ideas evolved over time, and AIA was eventually passed. So I think there will be some reform, but it'll be a few years from now, and Prevail may look different.
Yeah, you can't let the good become the enemy of the perfect, or vice versa. Because then nothing winds up happening. So let me, Clint. I'll
Just
give you the
one
opportunity.
last point on that.
Go
Just
ahead.
keep in mind, after the election, there'll be new committee leadership. So who knows?
Yeah, right.
Maybe para doesn't even get done.
Maybe, but what I understand that Congressman Issa is time limited on the IP subcommittee. I don't know that to be true. I haven't verified it myself. I heard that the other day. So that would be positive for patent owners who, despite his patent owning background, has not been particularly friendly to patent owners. But the whole landscape could completely, seismically shift in just a year's time. But let's say that it doesn't shift, and then we do have some people who want to get some stuff done. What do you think the odds are of the IPR kind of, let's call it streamlining the IPR and reexamination process pieces? Any Monday morning quarterbacking on those odds, or what you think might happen? Anyone? Scott?
My sort of gut bet for any legislation passing is low percentage chance with the way Congress works these days. Unfortunately, they can barely pass anything, including things that the vast majority of Americans actually think about and care about. And
Yeah.
so, the patent legislation is a difficult thing to get, other than you may not get a lot of opposition, but sort of when you hear something that says, I want to cut back on the ability to go to the patent office and have them revisit the issuance of a patent, there are a lot of people out there who will just say, no, I don't want that. And Congress hears that, and they hear enough no's, then the status quo remains.
Yeah. So, Clint, let's come back to you, because where you were taking us at the beginning, and we didn't follow that path completely, was, I think, sort of through a matrix of decisions that one might go through to decide whether or not to file a re-exam after an IPR, whether it's failed for whatever reason, and why you may want to do that and why you may not want to do that. Can you walk us through that in a little bit more detail?
Yeah, so just looking at kind of the salient differences between re-exam and IPR, one drawback for the requester, obviously, is it's ex parte. And in having conversations with a client that was thinking about doing this, one drawback is the ability of the patent owner to have an examiner interview and not get a fully developed record of what actually was discussed, and then the claims get allowed. Also, that in combination with submitting all the art from the invalidity contentions in an IDS, there's a little bit more mystery from the standpoint of requesters in terms of what is going to happen because once you file the re-exam, there's no pulling it back there as the requester. There's no settlement. There's no further chance to participate. So those are some of the considerations, I think, that people, defendants in a patent litigation that are thinking about how this is going to affect their trial. Those are some of the things they're looking at.
Yeah. So, Jim, let me ask you: do you have clients that will do this as a matter of course? Ones that more thoughtfully consider doing it? What matrix do you try and help people walk through?
No, I think the decision tree that Clint walked through, it makes a lot of sense, right? And I've not been involved in cases where we always got to file a re-exam, right? I think it's strategic. I think we have to look what led to the non-institution decision, and does it make sense given the pros and cons of a re-exam, and versus trying to put the case on in front of the jury.
Yeah. And how much of a concern is it that, in re-exam you can wind up, if the patent owner wants to, can wind up coming out with more claims? And in some cases, I've known people going into re-examination companies going in and come out with several hundred more claims, just as sort of like giving the requester a middle finger, And does that factor into this, that, you're not only going to potentially make this stronger, but you might make it broader too. And I know you can't broaden in re-exam, but you know what I'm saying there.
Right, and I think the remedies conversation is an important one in the decision tree, right? Back damages, right? If the patent owner amends, that could put a damper on that if it's a material amendment. And so coming out with new claims, there'll be a question of whether requester would be liable for infringement of those new claims.
It is a way to get leverage, though, and I remember back when the NTP re-examinations were going on, the NTP versus RIM to, turn off the BlackBerry in the Eastern District of Virginia. They went in and they filed hundreds of new claims, and almost all of them were multiple dependent. So in fact, there were thousands of new claims, and so certainly damages is a consideration. But if you're looking at a patent thicket that suddenly just got incredibly thicker, and you're conveying the message that, I'm going to get one of these thousands of claims through. It can be effective, and also just in terms of getting new claims, the examiners in the re-examination, aside from the record that's in front of them, aren't doing additional searching. So, you can, at least in theory, get claims easier in a reexamination than you could otherwise. So it is something that you have to think about.
Yeah. So, and I don't know, Scott, I know you were here. I don't know whether you guys heard Ben this morning when he was talking about, and it may be a fairly unique situation. That's kind of what I want to kick around. What kind of clients are you seeing making these kinds of decisions? I mean, because it would seem to me that if you had a beef with Ben's company, and you knew that Ben doesn't really care about damages, what he cares about is preventing you from doing what you're doing, and if he can get you off of Amazon for a couple weeks right at the right time, that's going to be, you know, $250,000 extra on the company's bottom line. How does that business reality factor into this decision? And if the answer is not at all in your practice, that's perfect, because I mean, I think a lot of you deal with situations where there's NPEs involved and there's $100 million litigation, and damages are a huge component. And it's not just, you know, the folks who are selling on Amazon or trying to prevent importation through the ITC, where they have a different set of concerns. Any thoughts on that whole area and how that affects decision making?
Well, I think
Jim.
trying to take out a thicket or a portfolio or a family, whatever you want to call it, in the PTAB is time consuming and very expensive, because it's one petition, one patent. And sometimes, if you've got 100 claims, it's multiple petitions because of the page lengths. Mm-hmm. So you know, Ben's strategy of a portfolio or a family, that's hard to challenge, you know, on the other side. Now, I will say, if you have continuations and you have terminal disclaimers, right, the courts have been dealing with that, right? We get into preclusion, continuation claims can go down for not being patently distinct. And so that would be a countervailing point, that if you go through and challenge the parent and this family isn't that much different, then that could be a problem for the patent owner. Mm-hmm. So one kind of summary point is Professor Duffy from Virginia said this years ago, that the play is a Swiss cheese portfolio, right? It's going to be hard to have a perfect asset, but you're going to have a family, and hopefully the cheese, the holes don't all line up together, right? And that's a problem for the defendant.
I like that. You know, and we had in our patent portfolio program last June, we had Cynthia from ZimV talked about it as a checkerboard kind of, you know, because you can't protect everything. So you got to pick what you're protecting and where you're protecting and that sort of thing. I like the Swiss cheese, though, with the holes lining up.
But when you do talk about competitors that are, you know, way low down on, you know, in terms of sophistication, and they're literally just knocking you off, reexamination does tend to be the one that they look at because it's cheaper. You know, they can file anonymously, so maybe you haven't targeted them yet, but they see what else is going on out in the industry. And, you know, so they file a low-cost reexam, and, you know, maybe it's not successful. You just keep filing them, right, until it comes your turn to get sued. Maybe you've been able to whittle down the claims to the point where the scope's changed. You know, you can copy 90% but not 100. So that's where I see sort of the lower end of the market playing challenges.
Does the anonymity of a reexam, does that need to change fundamentally if we're concerning ourselves on the IPR side with a real party in interest? And I know real party in interest, that we could do a whole panel on that, what that means and whether anybody follows it, but it's there, and I think the law is getting a little bit more sophisticated in that area. But go ahead, Jim.
No, the attorney that files has a certification, and that is not barred. So I think the attorney can run into trouble if we are in a failed IPR world and you want to file anonymously. You're okay, but if there's a full IPR and you want to try to file anonymously, the attorney wouldn't be able to certify that on its face.
Mm-hmm. And I guess that's enough, I guess.
Well, but we also have people in foreign countries, you know, especially on the trademark side, just filing whatever they want. So we know that there's attorneys out there, you know, that'll do or say anything. So,
well, yeah, and not only that, on that side too, I know OED specifically, when they come and talk the last time at one of our programs, they're having people with this micro entity declaration, you maximum of 4. applications, right? They have people that will submit a dozen within an hour. And it's like, okay, it's not a mistake. At that point in time, like, was it the fifth one? Oh, we forgot about that one. Sorry. No, it's you're submitting a dozen within 60 minutes, and so there are bad actors out there, and I don't know what the answer there is, but
I haven't thought through what the arguments are against listing the real parties in interest, but I mean, that seems reasonable, just making that tweak.
Yeah, I mean, because, going back to what Scott was saying earlier, is if you're going to try and defend these things, you really want to defend that you're able to do this anonymously? Because so much happens just because that's just always the way it's been done, but...
I mean, it does provide some value. If you're a small company and you're up against a behemoth, you don't want to pick a fight with them publicly, and maybe you're licensing their whole portfolio, and really only one patent is kind of relevant to your business. Maybe it's an IBM or one of these big licensors. If you can whittle away at that claim anonymously and not provoke a fight, that's what it's designed to do.
Right.
Whether or not that's the use that's prevailing today is another question.
So, and maybe I should have started with this at the very beginning. I mean, how many people, and Scott, maybe this is a question for you, since you were at the board for a while. I mean, how many re-exams are getting filed? I mean, how much of an issue is this at all to begin with?
So I think it became an issue primarily because of FinTiv. And so it was not much of an issue for a while. And then FinTiv came and people were saying, hey, wait a minute, I'm not even getting my day at the patent office at all. There are all these concerns about an ex parte re-exam and why you would prefer the IPR, but I tried the IPR and the agent just said, no, I don't want to do it. And so I want to get the agency to do it. And so I think we're still seeing it, even though FinTiv has waned. But so I think that there's still more re-exams, and that question is coming up more and more than it was early in the AIA days. But so I think it's still a consideration, whether you call it a problem or a good thing. It's still a consideration that people are saying, well, what about ex parte re-exam? And you end up with all the drawbacks that ex parte re-exam has compared with inter partes review. But they say, well, what? But I get to do it no matter what, right? And so isn't that? Should I be thinking about that? And you say, well, yeah, we can think about it. But so I do think it's still a consideration.
Yeah. So let me also ask you, and maybe I'll ask all of you this. And I meant to ask Tim this question when he was up, because during the prep call with the in-house panel, one of the things that I asked is FinTiv still an issue? And I was surprised by the answers that I got, because I thought it was not. I thought by now it was a big nothing burger, but is it, Scott, still an issue?
It is still an issue. I think that I personally was surprised. This is not on behalf of any clients, but my personal view is that it seemed clear to me that the way out of FinTiv was to do a Cetera stipulation, and it's just really, really, a lot of people are really uncomfortable doing a Cetera stipulation, and we've seen recently there have been some decisions where a company came in with one stipulation and they said, wait, I'll stipulate to even more. That might not have been enough. I'll stipulate to even more, but I'm not going to do a full Cetera. And a bunch of IPRs were denied under FinTiv because they hadn't gone the Cetera route.
So that doesn't bother me. To me, that seems like a self-inflicted wound. I mean, because that seems like the reason why you're doing that is specifically because you want 2 bites at the apple. Am I missing something?
I mean, I can't go into all the considerations that companies have, but if they get worried about they don't know what the scope of the estoppel is in the district courts. That the landscape keeps changing, so they get nervous about stopping themselves before the statute stops them, and that's basically what a Cetera stipulation does.
Some of the more sophisticated companies have looked at it as well. I've got 2 ways around FinTiv. I can file the Cetera stip, and now I don't have an invalidity defense for the most part in the predictable arts, or I can present a compelling case. So why don't I just not file the Cetera stip? If I'm compelling, then I want to go forward. If I'm not, I don't want the estoppel. So if I lose at institution, you know, it's the lesser of the two evils of I only want to go forward if I'm compelling. So why would I give up my invalidity case at the district court? I'd rather just ride out the institution, which I think from an academic perspective is probably the way to play it. But then you have to factor in the human nature of the judges looking at, well, all I have to say is this isn't compelling, and instead of writing 60 pages, I can write 10.
Right.
So I'm not sure that it always works out that way, but that's one way to think about it.
So, but that's a different type of fintive issue than what we were seeing earlier on, where the time to trial was factoring in. And
Well, there was no real compelling sort of carve out. That's Director Vidal introduced that.
Right. Okay, so Clint, any thoughts on that? I mean, fintive still an issue in your opinion?
Yeah, it still is an issue in rocket dockets. In the Eastern District of Texas, you know, for cases in ED text, it is an issue. And fintive still raises the issue that IPRs are treated differently if the patent's involved in litigation in a really fast court versus a slower court. And so it forces decisions to be made faster in the IPR process. It also forces the trial counsel to figure out if they want to make a Sotera stipulation, you know, to guarantee they're getting over fintive. And so I think it still is an issue in fast-moving courts, and there aren't a lot of those, but you know, there's still a few.
Mm-hmm. Jim, is still an issue for your clients?
Yes, absolutely. Because I agree with Scott that the Sotera stip has not been widely adopted, for better or for worse. And so you have the different types of stipulations, and there's a lot of different judges on the board, and how those less than Sotera stips play. When you put it into the multi-factor test, there can be, you know, it's put everything in the hopper and see what comes out. So it's unpredictable.
Yeah.
Do you mind if I follow up?
No, go ahead, Jim.
Scott mentioned the compelling merits that Director Vidal put in. You know, first you put in it as a complete get-out-of-fintive jail card free, and said, you know, if you have compelling merits, nothing else matters. And then she, quote-unquote, clarified to say, well, you still have to look at the first 5 factors before you get out of jail free with the compelling merits, which I didn't quite understand that clarification. Is it still a standalone get out of jail free card, even though you have to discuss the first 5 fintive factors?
I mean, I think the short answer is if it's compelling, it's probably going to control the determination. But you know, from a administration perspective, they just wanted to create the full record, and maybe you know, there are a couple judges that might see that as a more attractive way out if they don't have to write as much. You know, so you know, maybe it was just a control on quality.
Mm-hmm.
And it impacts how petitioners file their petition, right? The surreply. If patent owner raises fintive, a surreply is not guaranteed. And so if the petitioner doesn't expend their word count up front to try to pre-butt fintive, it could be a problem for them. Or if they want to file their stipulation later, before the institution decision, that's still being worked out, the procedure for that.
Okay, so we're down to about the final minute here, but I'd like to give each of you an opportunity to wrap up, and I can go in the order in which I introduced you. What do you think, Scott, we'll start with you, and what do you think people should remember about today's conversation? What do you hope that they take away?
I think what I take away from it is that this is an area of interest. It's an area that hasn't gone away, even though fintive has partially gone away. Fintive is still there as well, and so it's an area that clients should be thinking about and lawyers should be thinking about is how do we handle, do we do an ex parte re-exam? That sort of was a question that kind of went away for a while, and it's back, and it is a question that remains a viable question.
Great, thanks. Clint, your takeaway message.
I would echo that, especially when you look at the numbers of re-exams and the trends. The numbers bottomed out 2019, 2020, and they've been increasing ever since. And they even increased last year, despite the fact that the number of IPRs went down. So re-exams have been reinvigorated. They're a defense that defendants should think about in their toolkit. And it was mentioned, I think Scott mentioned, not just after failed IPRs, but even not every case is a $100 million case. You can have smaller damages cases, and you may want to think about ex parte re-exam as a less expensive alternative in that situation. And we're talking to clients that are looking at that in those situations where the damages are not astronomical, but it's still a tool. It's still a viable tool.
Okay, great. Thanks, Clint. Jim, your takeaway.
Yeah, I mean, re-exams predate the IPRs, PGRs by a lot. And so they've always been there, and I agree that they're getting a new look based on the interplay between discretionary denial and non-institution decisions. And so it's certainly something everybody should be aware of. And under the current system, it's really not 3 bites at the apple, right? District court, contested proceedings, and re-exam, but it's close to that, right? Because re-exam is a viable lane that can survive if it's a substantial new question.
Mm-hmm. Okay, great. Thanks a lot, Jim. And Scott, your final thoughts.
Yeah, I would say that this area is probably going to remain subject to debate. We will probably, if history is any indicator, have a new director. In the next 18 months. These issues are discussed in the Prevail Act. If that doesn't get traction, and it probably won't, you may have some push for the agency to step in and do some of this stuff, at least as between a party that had its chance in IPR and is now going back for a re-exam compared to the general public. We're always balancing the general public, because if it's an improvidently granted patent, we're taking something out of the public domain. But to have 2 bites at the apple, I think the optics of that probably drives some kind of incremental change there.
Yeah. Okay, great. Well, thank you very, very much. I really appreciate the conversation, guys. And we are going to take a break for lunch, so please join us in the back room for lunch. We'll pick up with our next panel at 2 p.m.